Hi, everybody. Welcome to our video recording of the Foster Youth Bill of Rights and Reasonable Prudent Parent Standard Training as presented by the Office of the Foster Care Ombudsperson.
Hi, everyone. My name is Kendra. I work for the California Office of the Foster Care Ombudsperson. I'm an analyst in the office and really excited to be here today to talk to you about foster youth rights and reasonable and prudent parenting standards.
Yes, hello everybody, and my name is Shekinah Preto. I'm OFCO, an analyst with the office. Excited to be here with all of y'all to talk about this Foster Bill of Rights and also Reasonable and Prudent Parent Standard. Hopefully you all get to learn something new at the end of this presentation.
So we're first going to talk about our learning objectives for today. So the learning objectives are for us to learn about the role, functions, limitations, and the laws that govern the California Office of the Foster Care Ombudsperson, or OFCO, to learn about the OFCO complaint process, to learn about the California Foster Youth Bill of Rights, and to learn about how to identify potential foster youth rights violation and uphold the Foster Youth Bill of Rights.
So what exactly is an ombudsperson? An ombudsperson is an impartial, independent person with the authority and responsibility to receive, investigate, and/or informally address and resolve complaints about government actions, and when appropriate, make systemic recommendations based on findings.
So we have many roles at the Office of the Foster Care Ombudsperson. So what do we do? So the Office of the Foster Care Ombudsperson is a neutral and independent office that helps solve problems and complaints about the care, placement, and services and rights of children and youth in foster care. We help foster youth, social workers, probation officers, resource families, and other advocates understand the rights of children and youth in foster care. And we also help by making policy recommendations to improve the foster care system. So if you are concerned about the rights of a child in foster care or issues related to their care, placement, or services, our office may be able to help. The OFCO, we also provide former foster youth in California with dependency letters, also called foster youth verification letters. We provide trainings such as the one that we're doing today on the Foster Youth Bill of Rights and on the Reasonable and Prudent Parenting Standards. And we also provide free Foster Youth Bill of Rights publications to foster youth, county child welfare and probation offices, foster family agencies, and congregate care facilities, group home shelters, and STRTPs as well. Now, we also have limitations. So there are certain things that our office is not able to do. So we can't change court orders and case plans, and we have no authority regarding personnel issues. So again, we cannot investigate any type of claims of child abuse or neglect. We cannot investigate complaints that have to do with judges, attorneys, or law enforcement. Our office cannot provide legal advice, and we cannot investigate any issues related to child custody, child support, and family court. So again, our office is not an emergency intervention service. If you have immediate concerns about the safety of a child, call your county child protective service agencies or your local law enforcement agency.
So what exactly is the complaint process of our office? First, we will listen. When you call our office, an ombudsperson's staff will answer the phone and listen to your complaint. They will ask you some questions to learn more about your situation. 2, we will investigate. If your complaint is accepted for investigation, it will be assigned to an ombudsperson's staff. They will do a thorough review of the issues in your complaint. 3, we will resolve. The ombudsperson's staff will work hard to resolve your complaint. They will try to come up with a solution that will protect the foster youth rights and support the youth's best interests. And 4, recommend. Our office uses the data from your complaint to analyze trends, write reports, and make policy recommendations that can improve the foster care system. So who exactly can contact the ombudsperson's office? Our office was created to serve foster youth, so foster youth calls are our first priority. However, anyone who is concerned about the care, placement, services, or rights of a child or youth in foster care can call our office. Are calls to our office confidential? We do have a confidentiality policy to protect the identity of people who call to make a complaint. The law allows us to release certain information to certain people in the process of conducting our duties. However, if we needed to share this information, we will tell you ahead of time. If there's a safety issue, we may also make a report to the appropriate agencies, such as the County Child Protective Services Agency or the Community Care Licensing Division. If this happens, we will discuss it further with you. Right after you contact the Ombudsperson's office, if it's a foster youth complaint, it will be processed within 1 business day. Foster complaints are our first priority. If any other person files a complaint on behalf of a youth, it will be looked into and screened as long as the concern is about the rights, care, placement, or services of the foster youth. We review each case through the screening process to determine if it needs further investigation. Some complaints may be referred to other places for resolution. If we do choose to investigate your case, we will notify you of our decision to investigate, offer periodic updates, and then also notify you of the closure of the complaint. All complaints made to our office may include a review of records, contact with relevant agencies, and also interviewing certain people related to the case. So now we're going to get into one of the biggest pieces of legislation that our office oversees, the Foster Youth Bill of Rights. The Foster Youth Bill of Rights applies to all youth in foster care and also probation youth who live in an out-of-home placement, such as an STRTP, or short-term residential therapeutic program, group home, or foster home, as well as any other child or youth living in any licensed or certified children's facility or home in the state of California.
Okay, so now we're going to talk about Assembly Bill 175. AB 175 is the Foster Youth Bill of Rights update. So some background on AB 175 is that it actually updated the entire Foster Youth Bill of Rights, which is under the Welfare and Institutions Code 16001.9, to now include 41 rights for foster youth. So AB 175 reorganized, clarified, and expanded the Foster Youth Bill of Rights. Now, the actual bill was signed on October 2nd, 2019, and it clarified the role of the Office of the Foster Care Ombudsperson as providing training and technical assistance regarding the Foster Youth Bill of Rights. The bill itself went into effect in January of 2020. So what it actually did is AB 175 updated and expanded the Foster Youth Bill of Rights into categories and themes of the rights relating to placement and well-being, communication, things such as cultural ceremonies, extracurricular activities, and cultural competency training, just to make it easier to identify potential rights violations for youth and their advocates.
In addition to updating the Foster Youth Bill of Rights, this also led to our office updating the publications to teach youth and other stakeholders about the foster youth rights. In these focus groups, our office went out throughout the state and asked youth what they would like to see and what kind of publications they wanted to learn more about their rights. In these focus groups, youth expressed that they wanted hard copies of the rights to hold in their hand. As a result, we created various publications, and in November 2020, the updated publications were released to the public. They include a coloring book for younger children, a teen handbook, a pocket accordion, and also a poster. All of these publications are available for free on our website. You could download them digitally, and they're available in English and Spanish, and you could also order them online if you would like a printed version. All of these are free to order, and again, all of them are accessible through our website.
So again, AB 175 updated and expanded the Foster Youth Bill of Rights into themes and categories. And so some of the rights categories that we currently have now are the personal rights, the ICWA or Indian Child Welfare Act, the SOGI, sexual orientation, gender identity expression. There's education rights, there's sexual and reproductive health, mental health. Youth have rights, easier to find by themes under family connections, CFTs, which is child and family team meetings, their court rights, their health rights, and their rights as far as adulthood and money management as well.
All right, so now we're going to dive into each of the categories to describe more about which rights apply to each category. In the personal rights category, youth have the right to live in a safe, comfortable home where they are treated with respect and to have enough clothes and healthy food, clothing, grooming, and hygiene products that respect their culture and ethnicity, a private place to keep their things, a phone they can use to make private calls unless the judge says they cannot, a caregiver that has special training on trauma and ways to help them. Youth also have the right to go or not go to religious services and activities of their choice, participate in cultural, racial, ethnic, personal enrichment, and social activities, and fair and equal access to all available foster care services, placements, care, and benefits. While youth are in care, no one is able to lock them in a room or a building unless they are in a community treatment facility, make them stay in juvenile hall because they can't find them a home, use law enforcement as a threat or retaliation, abuse them physically, sexually, emotionally, or exploit them for any reason, punish them by hurting them for any reason, looking through their things unless there is a reasonable or legal reason, or treat them unfairly because of race, ethnicity, ancestry, national origin, color, religion, sex, sexual orientation, gender identity and expression, mental or physical disability, HIV status, or membership in a federally recognized Indian tribe.
Indian Child Welfare Act, or ICWA rights. If a youth is a member or could be a member of a federally recognized Indian tribe, they do have the right to live in a home, or STRTP, that maintains the social and cultural standards of their tribe and their tribal community, to live in a home of their relatives or extended family, or a home that is licensed, approved, or specified by their tribe, to live in an Indian foster home that is licensed or approved, or a facility that is approved by their tribe or an Indian organization that meets their needs, to live in a place that reflects and keeps them connected to their cultural and social standards of their tribe and or tribal community, to be able to contact their ICWA advocate and have them attend court, and to be able to contact their tribal members and Indian community. Youth also have the right to have a social worker, probation officer, and a lawyer who is trained in ICWA, and to be able to participate in traditional Native American religious practices, to get help becoming a member of an Indian tribe or Alaskan village if they need it, and to get all the benefits that come from being a member of that Indian tribe or Alaskan village. Youth also have the right to be free from discrimination and be recognized for their relationship with their Indian tribe or Alaskan village, and to have the protections for their tribal relationship in their case plan.
Youth also have rights related to their sexual orientation, gender identity and expression, also known as SOGI. Youth have the right to live in a home or STRTP based on their gender identity. They have the right to be called by their chosen name and gender pronouns, the right to see a doctor or counselor who is gender affirming, to have clothing, grooming, and hygiene products that respect their gender identity and expression, to have a caregiver, social worker, probation officer, and lawyer that have been trained on SOGI and how to care for LGBTQ+ youth, and to keep their SOGI information private.
So youth have rights when it comes to school as well. They do have the right to go to school every day and to be able to get help with school. Youth have the right to stay at their same school, also called their school of origin if it's best for them, and to enroll right away at a new school, regardless of any documentation that might be needed. Foster youth also have the right to get partial credits for all classes they were passing if they have to change schools in the middle of the semester, and to be able to go to after-school activities. As it's age appropriate, they have priority enrollment in preschool and after-school programs. And again, with it being age appropriate for youth to have priority enrollment at California State Universities, UC, and community colleges, and to have access to information about college and career education programs as well.
Youth also have rights related to their sexual and reproductive health. They have the right to get information about their sexual health in a way that they can understand, to use or refuse services for birth control, condoms, other types of protection, and pregnancy care, including abortion, without telling an adult, to get healthcare services for sexual assault without telling an adult, and if that youth is age 12 or older, they also have the right to choose their own doctor or counselor and make decisions about preventing, testing, or treating STIs, HIV without permission from any adult.
Under mental health rights, foster youth have the right to keep their mental health records private and to be able to receive gender affirming mental health treatment. They have the right to work with their doctor to safely stop taking psychotropic medication and to refuse to take psychotropic medication, and no one can punish them for it. Youth have the right to know about their diagnosis and to understand their treatment options, and to get help with an alcohol or drug problem without permission, to get mental health services in a place that meets their needs. And if the foster youth is 12 years of age or older, they do have the right to choose their own doctor or counselor and make decisions about their own mental health.
Youth also have general health rights, such as the right to see a doctor, dentist, eye doctor, or talk to a counselor whenever they need, to see a doctor who is gender affirming, to refuse to take any medicines, vitamins, or herbs, and nobody can punish them for it, the right to keep their medical records private, and then also to have the risks and benefits of treatment explained to them in a way that is easy for them to understand.
Youth have rights at court. They have the right to be told about their court hearings in writing, and to be able to go to court and talk to the judge, and to tell the judge what they would like to have happen in their case. A foster youth does have the right to tell the judge how they feel about their psychotropic medication, and to ask the judge for visits with their siblings. They also have the right to request a hearing if they feel like their lawyer is not acting in their best interest, and to ask for certain people to be in the courtroom or ask for certain people to leave. They have the right to have their court records kept private unless the law does say otherwise, and to be able to tell the judge how they feel about their family, their lawyer, and their social worker or probation officer, and to have a lawyer representing them separate from the one that their parents have and the one that the county also has. A lawyer of a foster youth must keep whatever the youth tells them private, have special training on the Indian Child Welfare Act and sexual orientation, gender identity and expression. They also have to make sure that the foster youth is safe and they have the services and supports that they need, and that they also must tell the judge what the youth wants to have happen, and to answer any questions that the foster youth may have about court, foster care, and other laws.
Youth have rights related to their case plan as well. They have the right to help create the case plan and to have a case plan within 60 days of being in foster care. They have the right to have their case plan updated at least every 6 months and to be told of any changes made to the case plan. If the youth is age 10 or older, they also have the right to get a copy of the case plan. And if the youth is part of a federally recognized tribe and is protected by ICWA, they also have the right to have their tribe involved in the case plan decisions. Overall, a youth case plan is supposed to have their health and education plans, the best place for them to live, the services they need, a long-term plan for where they will live, gender-affirming healthcare plans, plans for visitation with their parents and siblings, a transition to independent living plan or TILP if they are age 16 or older.
Under child and family team rights, foster youth do have the right to request CFT meetings and to have support people at their CFT meetings and to be able to talk about their needs in the CFT meeting as well. CFT meetings should be held within 60 days of a youth entering foster care, and after that, there should be a meeting every 6 months. If we go back to the beginning where I say a youth has the right to request CFT meetings, that means if there is something that comes up that might be urgent, a youth doesn't have to wait 6 months. They are able to request a CFT meeting if there's something that they want to address and they feel that need. For youth who are in STRTPs or in therapeutic foster homes, a CFT meeting should be held at least every 90 days. And also a CFT meeting should be held at least every 90 days for any youth who are getting certain types of services. And a CFT meeting should also be held when any changes are going to be made to a foster youth case plan.
Youth also have rights to maintain their family and social connections, such as the right to visit and contact their parents, siblings, and other family members in private, unless a judge says that they cannot, and to contact people who are not in the foster care system, but are important social connections to them, such as friends, church members, teachers, and any others, unless a judge says that they cannot.
Preparing for adulthood and management. So foster youth do have the right to do some things on their own. youth do have the right to have an allowance that is age appropriate and to have their own bank account unless their case plan says that they cannot. They are able to learn job skills for their age, and they're able to work unless the law says that they are too young. Foster youth are able to earn, save, and manage their own money unless their case plan says that they're not able to. And they're able to go to an independent living program or IOP if they're old enough. And also beginning at age 14, foster youth are able to get a credit report every year from 3 major credit reporting agencies and have help fixing any issues that might be there.
With communication rights, youth have the right to use a phone to make and get confidential private calls, and also to use a computer and the internet. Youth also have the right to privately use email, text messages, or other electronic communication, and to also send and receive unopened mail. These rights can only be changed if there is a safety concern, and only a judge can take these away or stop youth from communicating with certain people. Youth also have the right to contact the following people in this list in private, and nobody can stop them or punish them for speaking with these individuals or agencies. This includes the youth social worker and probation officer, the lawyer, service providers, foster youth advocates, and court-appointed special advocates or CASAs, the education rights holder, the youth's tribe if they have one, our office, the Office of the Foster Care Ombudsperson, and community care licensing, also known as CCL.
Record rights. Foster youth do have a right to see and get a free copy of the following records until they're 26. Their medical records, their child welfare records, their juvenile court records, or their educational records. So if they were to need copies of these records anytime prior to turning age 26, they would not have to pay for them. Basically, having been in foster care and having proof of that, that would entitle them to receive these records for free up until their age 26.
So there is a mandate that exists in which social workers and probation officers must review the rights with foster youth every 6 months and before every placement change. Youth also must be given the contact information for community care licensing and our office, the Office of the Foster Care Ombudsperson, at each placement. Youth should be allowed to contact these agencies in confidentiality without threat or punishment for making a complaint. All right, so now we're going to go ahead and jump into a game to see if you all remembered what we have learned about the different Foster Youth Bill of Rights categories. So in this game, we're going to read a following scenario, and you will have to determine if it's a foster youth rights violation. Yes means it is a violation, and no means it is not. If you want it to be a little more interactive, feel free to pause the video during the question to answer it yourself, and then you can resume playing it to see if your answer was correct. So we're going to go ahead and dive into the first scenario question. 2 siblings are placed in your home. You decide to give the 16-year-old an allowance, but not the 10-year-old. Is this a Foster Youth Bill of Rights violation? Yes, youth have the right to an age-appropriate allowance. There is no age limit to this right. However, there is no state statute or regulation determining allowance amount or type. Agencies may provide guidance to resource parents, but if that does not exist, then resource parents are to use RPPS to determine appropriate allowance frequency, amount, and type based on the youth's age, maturity, developmental ability, and other factors. So in this case, depriving a youth of an allowance based on age would be considered a rights violation.
A youth is placed in your home. The youth asks if you can purchase a shampoo and conditioner that is specific to their hair type. You tell them no and that they must use the products in the bathroom. Is this a Foster Youth Bill of Rights violation? Yes. Clothing, grooming, and hygiene products such as hair products should respect a youth's culture and ethnicity. So this would be a foster youth rights violation for the foster parent to tell the youth that no, they would not buy them the specific type of shampoo and conditioner.
A youth has just been placed in your home and their school is located 45 minutes away. You enroll the youth into a school closer to your home due to transportation restraints. Is this a Foster Youth Bill of Rights violation? Yes. Youth have the right to stay at their school of origin if it's best for them. There should be active efforts to coordinate transportation if barriers exist. This planning can be done through child and family team meetings. So in this case, because there was no active efforts done to maintain the youth in their school of origin, this would be considered a foster youth rights violation.
A youth comes back to your home after going on a field trip at school. You search their backpack to make sure they are not bringing anything inappropriate. Is this a foster youth Bill of Rights violation? The answer would be yes. Youth have the right to not have anyone look through their things unless there's a reasonable or legal reason. Even if the youth is on probation, the resource parent should notify the probation officer about the situation so they can respond according to the youth probation supervision terms. So this would be a violation, yes.
A youth uses a messaging app to stay in touch with friends. You remind the youth to be safe and appropriate when using social media. Is this a foster youth Bill of Rights violation? No, this is not a violation. Youth have the right to use a computer and the internet to maintain connections with family and friends, but resource parents are encouraged to discuss safe internet and social media usage with youth.
The youth requested to have their significant other attend their upcoming CFT meeting. However, the significant other was not invited because they encouraged the youth to stay out past curfew in the past. Is this a foster youth Bill of Rights violation? The answer would be yes. Youth have the right to have support people attend their child and family team CFT meetings. It is encouraged to use CFTs as a way to resolve issues collaboratively. And in this case, a CFT is a great opportunity to talk with the youth about rules and boundaries regarding curfew.
A youth takes Adderall in the mornings to help manage their ADHD. The youth wakes up one morning and decides they don't want to take it anymore. You decide to restrict the youth from attending after-school drama club until they resume taking the medication or talk to a doctor. Is this a foster youth Bill of Rights violation? Yes. Youth have the right to refuse to take any medicines, vitamins, or herbs, and no one can punish them from it. Even if the medication is approved, best practice is to encourage the youth to make an appointment with their doctor and talk about their concerns and to tell the judge their opinion about the medication.
A youth who identifies as a trans girl is placed in your home. The youth's preferred pronouns are she, her. You call the youth by these pronouns, even though the birth certificate says otherwise. Is this a foster youth Bill of Rights violation? No, this is not a violation. Youth have the right to be placed in a home according to their gender identity. Calling a youth by their preferred name and gender pronouns upholds their rights.
A youth wants to know more about birth control options. They ask if you can help them get connected to resources to learn more. You refuse to help because you believe they are too young to know about these things. Is this a foster youth Bill of Rights violation? Yes. Youth have the right to have age-appropriate and medically accurate information about reproductive health care. There is no age limit to this right.
A youth just turned 11 years old and tells you that they would like to choose their own medical doctor. You tell the youth that they need to stick with their current doctor. Is this a foster youth Bill of Rights violation? No, this is not a violation. Only a youth 12 or older can choose their own medical provider. However, a conversation should be had with the youth to provide comfort and take their opinion into consideration when feasible.
Alrighty, everyone, and that concludes our Foster Youth Bill of Rights section of the presentation. So now we're going to head into a 5-minute break. We'll have a timer here on the video so that you'll know when to return. So please feel free to get up, stretch, get a snack, do what you have to do, and we will see you in the next 5 minutes.
So now we're going to jump into Reasonable and Prudent Parent Standard, also known as RPPS. It's not a philosophy about parenting, it's actually the law. So for some background history on RPPS, it was started by the Preventing Sex Trafficking and Strengthening Families Act of 2014, in which it was mandated that designated state authorities to develop a reasonable and prudent parent standard for the child's participation in age or developmentally appropriate extracurricular, enrichment, cultural, and social activities, and apply the standard to any foster family home or child care institution receiving funds under Title 4A Part E. The goal is empowering caregivers to make parenting decisions that support normalcy in youth's lives.
So normalcy, what is it? Normalcy is a focus on permanency. It's a connection to family, friends, and adult supporters. It's the ability to participate in routine activities such as sports, field trips, parties, etc., and the ability to develop independence, such as getting a driver's license, having responsibilities, etc. This applies to all children and youth in foster care in all home settings.
So why does normalcy matter? It allows youth to explore and develop interests and talents, safely experiment and practice decision-making, develop healthy relationships with peers and adults, and support overall well-being. In All County Information Notice 12815, it states that a child who has been placed in a foster home has suffered not only from the circumstances which led to the removal, but also from the trauma of losing everyday contact with their parents, other family members, and friends. It's critical that the home in which the child is placed provides, to the greatest extent possible, an environment in which they can experience all of the opportunities available to children who are not in foster care.
What is RPPS? So the All County Letter number 1631 gives California's background of the standard of what RPPS is. And what the Reasonable and Prudent Parenting Standard is meant to do is to eliminate unreasonable limitations on everyday activities and to ensure normalcy for youth in the foster care system. This standard eliminates overly restrictive practices and allows for participation in age-appropriate activities such as sports and extracurricular events, getting haircuts, staying over with friends, and obtaining a driver's license. So the Reasonable and Prudent Parenting Standard is basically using careful and sensible parenting decisions that maintain the youth's health, safety, and best interests, while also encouraging the youth's emotional and developmental growth. A caregiver shall use reasonable and prudent parenting standards when determining when to allow a child in foster care under the responsibility of the state to participate in extracurricular, enrichment, cultural, and/or social activities.
So according to All County Information Notice I-2815, it's necessary for resource parents to consider the following when making an RPPS decision, such as the child's age, maturity level, and developmental level, the nature and inherent risks of harm, and the best interests of the child based on information known by the caregiver. No two persons will actually parent in the same exact way. Therefore, no two caregivers will apply the Reasonable and Prudent Parent Standard in exactly the same way either. Overall, each caregiver must evaluate situations as they occur and make decisions based upon their own sense of what seems appropriate, given the unique characteristics of each child, again, based on factors such as age, maturity level, history, length of time and placement, past behaviors, etc., the nature and inherent risks of harm with that specific activity, and the best interests of the child based on information known by the caregiver.
RPPS applies to day-to-day and routine or typical caregiver decisions regarding chores, watching TV, playing video games, as well as participation in age and developmentally appropriate school, extracurricular, sports, social, cultural enrichment, field trips, and similar activities.
One way that RPPS is applied is through a framework of QPI, also known as Quality Parenting Initiative. According to All County Information Notice I-2815, QPI aims to strengthen foster care by ensuring that a foster caregiver provides the loving, committed, and skilled care the child needs while working effectively with the child welfare system to achieve the child's goals. It also seeks to clearly define and articulate the responsibilities of caregivers and to align child welfare policies and practices with quality foster care. Overall, QPI has resulted in numerous systemic changes and improved relationships between youth in foster care and also their caregivers. Some of these improvements include fewer unplanned placement changes, reduced use of group care, fewer cases of sibling separation, and more successful instances of reunification. The 5 core principles of QPI include: 1, excellent parenting is the most important services we can provide to children and youth in care. Children need families, not beds. 2, child development and trauma research indicates that children need constant, consistent, effective parenting to grow and reach their full potential. 3, each community must define excellent parenting for itself. 4, policy and practice must be changed to align with the community's definition of excellent parenting. And 5, participants in the system are in the best position to recommend and implement change.
The QPI and RPPS intersections. So caregivers and bio parents and everyone on the child's welfare team should work together for the best outcome of the youth. Caregivers can learn about the youth by talking to bio parents about their medical needs, their favorite toys, their favorite foods, etc. Caregivers can also encourage communication between the youth and their bio parents when it is appropriate and allowed.
All right, so now we're going to try to see if you all were listening to the different frameworks that define RPPS and test to see if these specific scenarios apply to RPPS. So what we'll be doing is similar to the foster youth rights violation game, is we'll be sharing a scenario, and if you believe that the scenario is something that a resource parent can make a decision on, then it would be a yes. If you believe that is not a decision that a resource parent can make, then it will be a no. And again, if you want it to be more interactive, feel free to pause during each scenario so you can quiz yourself to see if your answer is the correct one. So we're going to dive into the first scenario. It's Friday night, which means a date night for the resource parents. Since you will be away for a few hours, you arrange for a short-term babysitter to provide care and supervision to the youth. Is this reasonable and prudent parenting? Yes. An occasional short-term babysitter is a person who cares for a foster child in or out of the caregiver's home on an occasional basis for less than 24 hours at a time. They may be younger than 18, but must have the maturity, experience, and ability to provide the foster youth adequate care and supervision. A foster youth may, but under no circumstances shall be required to, act as an occasional short-term babysitter.
You're planning a family vacation this summer to Disneyland, and you want to take the youth. You do not have to obtain a court order for travel. Is this reasonable and prudent parenting? Yes, this would be. There is no state law or regulation that requires a court order for out of county or out of state travel. However, county placing agencies and local courts may adopt policies and rules regarding this, provided that they are consistent with Welfare Institution Code 362.05 and do not create undue barriers to prevent youth from participating in social activities. Judicial approval may be warranted for trips of great length or duration. Foster youth cannot travel out of county if jurisdiction has not yet been established.
Winter ball is approaching and the youth asks to stay until the end of the dance, which is over at 10 p.m. The house rule state curfew on the weekends is 8 p.m. You agree to allow the youth to stay, but require the youth to check in via text message every 2 hours. Is this reasonable and prudent parenting? Yes. A resource parent can set a reasonable agreement, such as checking in while youth does an extracurricular, cultural, racial, ethnic, personal enrichment, and social activity, as long as it does not deprive the youth of their right to engage in the activity. Resource parents are encouraged to consider how appropriate the activity is and if it maintains the youth's health, safety, and best interests while promoting normalcy.
You have to go to the grocery store to pick up a few things for the week. It's always a hassle to get your 8-year-old youth to go to the store with you. Since you will only be gone a few hours, you decide to leave the child home until you return. Is this reasonable and prudent parenting? No, this would not be a reasonable and prudent parenting decision. A resource parent cannot make this decision. A foster youth can only be left home alone on an occasional basis at age 10 or older. The youth cannot be left unsupervised overnight. RPPS shall be applied to determine the appropriateness of leaving the youth alone. The resource parent should ensure that the youth knows how to contact them, what to do in an emergency, and where emergency numbers are posted.
You attend weekly religious services. For the past 3 months, everyone has wanted to attend. A new youth arrives in your home and tells you they do not want to attend and will stay back. You inform the youth they must attend because everyone else is going. Is this reasonable and prudent parenting? No, a resource parent cannot make this decision. This would be considered a foster youth rights violation. Foster youth have the right to attend religious services and activities of their choice, and they have a right not to be discriminated against because of their religion or forced to participate in religious activities. So in this case, the foster youth right supersedes RPPS decision-making. If it's appropriate, the youth may be left home alone, or a short-term babysitter can be called while you attend that religious service.
You ask the youth to complete their after-dinner chores. 2 hours later, you notice the chore has not been completed because they have been talking to their friends on the phone. You decide to temporarily restrict the use of the phone until chores are complete. Is this reasonable and prudent parenting? Yes, the resource parent may place reasonable limitations on cell phone usage so long as communication with relatives, social workers, authorized representatives such as attorneys, foster youth advocates, and supporters, court-appointed special advocates or CASAs, and probation officers are not restricted. This would also include the youth tribe, their education rights holder, the Office of the Foster Care Ombudsperson, and community care licensing.
Overall, the Foster Youth Bill of Rights is meant to empower, not hinder, the ability for resource parents to care and provide for youth. There is no official guide to parenting. However, the Foster Youth Bill of Rights is pretty close because it does provide guidelines and expectations for how children and youth in foster care should be treated. It establishes that parenting decisions should consider the following: 1, existing court orders; 2, the Foster Youth Bill of Rights; and 3, reasonable and prudent parent standard. And if any resource parents want to know more information about reasonable and prudent parent standard and how to make certain parenting decisions, there are Owl County information notices available, and the links are in the description here on the slide. So now we're going to review some of the frequently asked questions that we've received from our attendees who have attended our training facilitations. One of the most common questions we receive is, do I have to give my youth an allowance? The answer is yes. Youth have the right to receive an age-appropriate allowance and to maintain a bank account and manage personal income consistent with their age and developmental level unless prohibited by the case plan. So as we reviewed in Reasonable and Prudent Parent Standard, it is up to that resource parent to use RPPS to make sure that the allowance is appropriate for that youth's age, maturity, developmental level, and that allowance allows the youth to practice budgeting skills, money management skills, and adulthood skills.
Another frequently asked question is, my youth has a gender identity that I am not familiar with, and they use pronouns that I am not used to. What should I do? So the answer would be to refer to your youth with the name or gender pronouns that they want to be called by. The youth have the right to be called by their preferred name and gender pronouns, and to have caregivers that know how to care for LGBTQ+ youth.
Another commonly asked question we get are things related to sexual and reproductive health services and a youth's age. So for example, my 14-year-old youth went to Planned Parenthood and received sexual and reproductive health services without notifying me. Is this something they are allowed to do? And the answer would be yes. Youth have the right to have age-appropriate and medically accurate information about reproductive health care. There is no age limit to this right, And as we reviewed in the Foster Youth Bill of Rights sexual and reproductive health category, they do not have to notify an adult if they try to get these services.
So we get a lot of questions regarding the rights of youth to maintain contact with family members, visitation, and their personal rights and communication. So my youth wants to visit their relatives. Are they allowed to go? The answer would be yes. Youth have the right to visit and contact siblings, family members, and relatives privately, unless prohibited by court order, and to ask the court for visitation with their siblings. But coordinating logistics such as scheduling and transportation can be done with the youth social worker and probation officer. But you do have a right to maintain social contact. So, very good question.
And kind of similar to the previous question, we also get a lot of questions regarding youth and their ability to maintain friendships and just do everyday children, teenager activities. So for example, my youth wants to have a sleepover at their friend's house. Are they allowed to go? The answer would be yes. Youth have the right to extracurricular, cultural, racial, ethnic, personal enrichments, and social activities. Under RPPS, resource parents must consider the youth's age, maturity, and developmental level, the nature and inherent risks of harm, and the best interests of the youth based on information known by the caregiver. So overall, if you as the resource parent believe that the youth would be safe in the home, if you want to get to know that youth's parents, you want to meet up with the youth who are going to be at the sleepover, if you want to make sure to set some boundaries and ground rules, that would all be appropriate if you're using RPPS, because youth do have the right to engage in these kinds of personal social activities.
One of the most frequently asked questions that we get under the communication is, a youth was placed in my care and they have a cell phone. Are they allowed to keep it? So it's regarding communication rights and the rights of youth to have cell phones. And yes, the youth do have a right to make, send, and receive confidential telephone calls and other electronic communications, as well as to send and receive unopened mail unless prohibited by court order. So if foster youth do have cell phones, that is a right that they do have in order to be able to make confidential telephone calls. So they do have a right to have a cell phone, again, unless a court order says that they cannot.
A youth was placed in my care and they do not have a cell phone. So this is kind of the reverse of the previous scenario. Am I required to buy one? So the answer here is no. Caregivers are not required to purchase a cell phone or pay for the youth cell phone service. So if a youth gets into your care and they do not have a cell phone, again, you're not required to purchase one as the resource parent. However, there is a great program called the I Foster Free Cell Phone Program that does provide free phones and free service to foster youth. So if you as a resource parent are interested in getting your youth a cell phone, you can learn more about this program by going on our website at fosteryouthhelp.ca.gov to help that youth sign up for a free cell phone.
So I'm not getting the support I need to care for my youth and I feel overwhelmed. Can I give a notice for them to be removed? So this is one of the frequently asked questions that would fall under Assembly Bill 2247 or more about placement preservation. So placement preservation is required before giving a 14-day notice unless certain exceptions are met. If you feel overwhelmed and urgently need assistance, you can also contact the California Family Urgent Response System, also known as CalFIRST. Their number is 833-939-3877. They can respond over the phone, and also they can respond in person during situations of instability in order to preserve the relationship between you and your foster youth. The priority is always to try to preserve the placement before putting in a 14-day notice and disrupting the placement of a youth. Under RPPS, the foster youth right for the youth personal rights to be in a safe, healthy, comfortable placement would actually supersede the RPPS, but placement preservation is very important. And this is a really good question for people to know and to understand. that it would be a 14-day notice versus a 7-day. And again, that the priority is to try to preserve the placement before removing the youth.
And that rounds up our video presentation. If you have any questions about anything that we went over in today's video, you can contact us at our hotline, 877-846-1602. We're open Monday through Friday from 8 a.m. to 5 p.m. You can also email us questions at fosteryouthhelp@dss.ca.gov, or also visit our website at fosteryouthhelp.ca.gov if you want to know more about the foster youth rights and other resources. We also have social media available. You can follow us on Twitter, Instagram, and Facebook, and message us through those platforms as well, and we can help answer any of your questions. And that will be the end of the presentation.
So thank you, everybody, for joining us today for our training. We were so happy to be here to provide it to you, and really hope that you learned a lot about Foster Youth Bill of Rights and RPPS. It was my pleasure.
Yes, same here. Thank you all so much for watching this video. And again, feel free to contact our office with any questions or follow-up. We're here to provide support and information about the rights to make sure that all of us can work together to uphold the rights of youth in foster care throughout the state of California. Thank you for watching, and see you all again next time.